ਐਡਵੋਕੇਟ ਜਗਮੋਹਨ ਸਿੰਘ ਭੱਟੀ YouTube ਚੈਨਲ ਅੱਜ ਤੁਹਾਡੇ ਵਾਸਤੇ ਇੰਡੀਅਨ ਜੁਡੀਸ਼ਰੀ ਇਜ਼ ਇੰਡੀਪੈਂਡੈਂਟ ਔਰ ਇੰਡੀਅਨ ਜੁਡੀਸ਼ਰੀ ਇਜ਼ ਇਨ ਡਾਇਲੇਮਾ ਔਰ ਇਜ਼ ਇਨ a confusion with the government. What is coming on the controversy in the corridors of the courts, in the corridors of the High Court, Supreme Court, and various other platforms. Unfortunate is the situation prevailing. And once upon a time, about few months back, Honorable Chief Justice of India, N.V. Ramanan, said, our Indian judicial system is at par with the UK judicial system, and that was a mere statement without any substance. And what was that? We discussed, and today again Honorable Chief Justice of India D.Y. Chandrachud is facing certain problems, and problems are from those who are the instrumentalities of the system. So let us talk on this, and talk should be reasonable.
Unfair. Okay, well friends, today on the request of Bhatti Sahab, I am once again before you all. Lately, there have been reports in media regarding the dispute and conflict between the government and judiciary about the collegium system. This system, which came into existence in 1993, after the second judge's case, the Supreme Court decided that the apex court has the power to appoint judges in the high courts and in the Supreme Court. But lately, the government has decided that this system is not foolproof because it lacks accountability, it lacks transparency, and it lacks credibility also. So, the debate is very hot. In the second judge's cases, the Supreme Court found that their wisdom is better than that of the Constituent Assembly. To my mind, the NJAC, that is National Judicial Appointments Commission, is a very fair and perfect model for the appointment of the judges, because the Supreme Court itself is a creation of the Constitution, it is a creation of the legislation, and it has to function under the government. I fail to understand that why the judges, including the Honorable Chief Justice, are afraid if the law minister happens to be one of the members of the collegium system. They should not feel nervous, because the law minister is not going to bulldoze the Honorable Chief Justice of India and the three other senior-most judges of the Supreme Court who sit together to appoint judges in the high courts as well as in the Supreme Courts. There have been favors and disfavors regarding the appointments of the judges in the high court, and people feel that some kind of bargaining also goes on regarding the appointments of judges. As an ordinary citizen, I have observed that mostly the sons and daughters and wards of the former judges are being appointed as judges, as if the other advocates lack any credibility, or they have no sound legal acumen, or they are not men of impeccable integrity, or they do not have any sound command over the language. So this seems to be a family business. Rather, it seems to be a dynasty, that just as in the old eras, the son of a king used to be a king, then his son used to be a king. So now it has become a family business that the son or the daughter of a judge will become another judge in future. So the criticism against the collegium system is not frivolous, it is not baseless, because advocates do feel that this is not a fair and a perfect model. To my mind, National Judicial Appointments Commission is a very good and a very fair and a very perfect model because it is plural in character. And since the judges of the High Courts and the Supreme Courts, they are public servants, they are drawing salary at the cost of public exchequer. So they cannot say that we are supremo. The Supreme Court doesn't enjoy absolute power, and there can be no arrogation of absolute power to the Supreme Court or to the High Courts because they have to work within the framework of the Constitution, which is supreme. And that is why after the second judge's cases, another case came up. That was the fourth judge's case in 1995, where the Supreme Court examined the validity of National Judicial Appointments Commission. And then came Article 124(1) and 127 of the Constitution. We the people of India. So we the people of India are sovereign. And in a constitutional democracy, no system is perfect. Whether it is the collegium system or whether it is NJAC, but every institution must strive hard to make improvement so that the citizens of this country are not deprived of justice. I'm very glad to know that lately the Honorable Chief Justice of India, who is a dynamic and visionary Chief Justice, said that the justice should be citizen-centric. But here, our judges of the High Courts, they don't bother even about the judgments of the Supreme Court in several cases, and they must realize that the judgments of the Supreme Court are the law of the land, and they are binding, they are mandatory, and they are not obligatory. So they must act in accordance with law so that the faith of the people, the belief of the people in our sound judicial system is not eroded. It is not that all judges are unfair, and it is not all that all judges are fair also, but there should be some harmony and balance. There is an old adage that justice is not to be done, but it should seem to have been done. I am reminded of a favorite quote by Pandit Nehru, who once said that so long we do not adhere to right means, the ends will not be right and fresh evil will flow from it. Another great writer, American writer William Penn, he once said that men will either be governed by gods or they will be ruled by tyrants. And this is the kind of tyranny and this is the kind of chaos which we are facing in our country. Only 2 years back, one of the judges of the Apex Court said openly in the Supreme Court that several litigants are victims of judicial terrorism. Now, these two words are very dangerous. Judicial terrorism. Now, meaning thereby that people are not getting justice in accordance with law. So, to my mind, let there be harmony, let there be a balance so that the executive and the judiciary, they work. Because in the Constitution, one word is there that the Apex Court, while appointing the judges in the High Courts or in the Supreme Court of India, will take into consideration the advice of the government. But it has to be concurrent. It has to be with the concurrence of the government, because the government says we are the paymasters and they are public servants, they are drawing salary. So why there should not be any uniformity between the executive and the judiciary, between the legislative and the judiciary? All the three pillars of the democracy, they have to work hard, they have to strive for the welfare and betterment of the people and not for their own betterment and for their own welfare. So my friends, I strongly feel that collegium system may be all right, but in the recent past, the appointments of judges have not been made in an objective manner. They have been made in a subjective manner also. And that is why this kind of system has created a heartburning in the minds of so many deserving advocates. Now the question is that where are the good judges? Now the answer is that if we have good advocates, we can have good judges also. But we must remember that an unscrupulous advocate can never be an upright judge. So before appointing the judges, we must take utmost care regarding their integrity, regarding their accountability, regarding their credibility, regarding their legal acumen, regarding their command over the language, so that they deliver justice, and not only justice, full, fair and complete justice to the people of this country. Thank you very much, friends. Wish you all the best.
Before you leave, there is a question. You simply said in your communication that government says we are the paymaster.
Yeah.
But here the government forgets, and or it is a misnomer on the part of the government. It is the taxpayers' money
Of course.
which is utilized for the payment of judges, and where we the people of India or the taxpayers are.
That is there, but the Supreme Court should not be under an erroneous impression that they are the Supremo. No, they are not, because they work under the law and under the Constitution, being the creation of the legislation.
Acumenship will emerge if there is a reasoning in the orders, and Watson rightly said, if no reasons are in existence, the law is lifeless.
Of course.
What do you say about
Of
this?
course. No, Fuller once said that every law is a law, but every law must have inner morality. So a reasonable order, or an order which has no reason, which has no logic, which has no rational, is no order in the eye of law, and it is a nullity in the eye of law, and it should be considered as void ab initio.
Many times the constitutional soul has been attacked in a number of ways by way of amendment, and Keshwanand Bharti versus Union of India rightly challenged His Holiness the amendment which was not in the interest of the public, and now even all holinesses of the India and the people of India, right-minded people and PIL people, are either sleeping or are forced to shut their mouth under the garb of contempt. What do you say?
Right, you see, once Lord Denning once said that the right-minded people go away with their thinking, this shows that the judge is biased. A judge has to be fair, a judge has to be absolutely impartial, without any fear or favor to anybody.
Lord Justice Denning, you rightly said and pointed out, and I'm, you see, fond of his reading judgments. He said, our judges are respected till their last breath. Is there any sound reasoning in this?
Well, you see, as far as our judges are concerned, the rot lies within, and it is for the judges of the High Courts and the Supreme Court to introspect that what has gone wrong, where it has gone wrong, and why it has gone wrong, and why people have lost faith in the credibility of our judicial system.
That is the reason every next day or every next hour the Honorable Supreme Court says and reiterates this principle: public faith be not shaken, public confidence be not broken. Likewise, such phrases are coming in number of judgments, and if you see and find the judgments of the Honorable High Courts as well as the Honorable Supreme Court are in many times. Now, why I am saying in many times, previously it not used to be in 1983 or prior to that, but now these are without substance.
Of course. You see, application of legal principles is of utmost importance. And I have read the judgments of some of the judges of the High Courts. They are not worth reading, because they neither have any content nor do they have any substance. And sometimes I feel that our High Courts are simply working like another government department. They simply dispose of the cases without giving their opinion and ignoring the law of the land. Now, this is not fair, and this is something very disgusting and dangerous also.
Here I would like to object to your word opinion. the High Court judges are neither of the view or nor they can express any opinion. It is the prerogative of the advocate or the legal consultants, and they are not overstepping the jurisdiction which is casted upon them by virtue of Constitution of India.
Well, Bhatti Sahab, only lately our Honorable Chief Justice D.Y. Chandrachud has said that a good judgment comes out of a good argument. So the bar and bench, they are not only supplementary, they are complementary to each other also. And the Chief Justice also said that an advocate who comes to the court of law without any preparation, he is just like Sachin Tendulkar without any bat. So it is the duty of both the advocates and the judges to deliver justice to the people at large.
So it was a communication which you may appreciate or you may give us feedback, and kindly subscribe my YouTube channel Advocate Jagmohan Singh Bhatti Advocate, and I request you to further give your feedback. All the expression as expressed by my friend Anil Bhatia ji is his personal view, and it is coming out of the gathering of the opinions of the public life, and vast experience of 35 years litigation which he personally suffered. Thank you so much.
All right, thank you very much, Bhatti Sahab. Thanks a lot. Thank you. कैमरा बाहर थोड़ा ऑफ निकलो महाराज उन सालों अपनी कैद से आजाद करो कितनी गलती हो गई थी
17
बोले 45 मिनट बोले हैं सर बैठ के सामने वाले को